Another exclusion that you can expect to see anytime you have securities litigation and people are alleged to have done bad things and gotten money as a result of bad things that they've done, frequently what you'll see are certain individuals within a company doing things to increase the chance that they get a bonus, to increase the size of their bonus. They're alleged to have engaged in bad conduct and somehow gotten more money as a result of that bad conduct. And because of that, the insurance company will look at those allegations and say, aha, the personal profit exclusion applies. And the personal profit exclusion essentially says that if somebody receives money that they shouldn't have otherwise received, there's no coverage. The personal profit exclusion, to start, just like the fraud exclusion, requires a final adjudication adverse to the insured. So again, we've got that same appeal issue. But more importantly, case law interpreting the personal profit exclusion courts have said that this exclusion applies in the very narrow situation where you have someone engaged in insider trading. And because of their insider trading activities, they've gotten money to which they were not otherwise entitled. And in that situation, the exclusion would apply. In any other situation where you're talking about an increased bonus or some other money received to which one might argue the individual was not entitled, the coverage applies. The personal profit exclusion is irrelevant. And there's one other point I'd like to make when we're talking about fraud, intentional conduct, the exclusions under the policies for bad acts. In many jurisdictions, there is statutory authority. In California, we have an insurance code called Insurance Code Section 533 that says there's no coverage for willful conduct. And what insurers will do is they'll say, okay, the fraud exclusion, maybe you're right, and we've got to wait to see if there's a final adjudication versus the insured. But that doesn't matter because we have public policy arguments and statutes in certain jurisdictions that say willful conduct is not covered. And they'll rely on that to exclude coverage. Well, an important point to keep in mind is while Insurance Code 533 may be relevant to indemnity dollars, settlements, judgments, case law in California has been very specific to accept from the impact of Insurance Code 533 defense dollars. So if you are incurring defense dollars in litigation where fraud is alleged or intentional conduct is alleged, don't presume that something like Insurance Code 533 will apply because defense dollars are accepted and those are covered. These are very important points because if the insurance company is going to come up with bases to avoid coverage, the insured needs arguments on the other side, and there are many arguments that the insureds can make to protect their ability to, at the very least, have their litigation paid for.